Well, Elon Musk remains defiant as he defends himself in federal court. Tesla shareholders sued him over a 2018 tweet about securing enough funding to take the company private. Musk testified in court this week, insisting that he had, quote, no ill motive over the tweet about the alleged buyout. So joining us now for more on this is CBS News legal contributor Jessica Levinson. She's also a professor at Loyola Law School. Good morning, Jessica. I know that Musk said at the time he thought he did have the funding secured, so that wasn't not an inaccurate tweet in his mind. What is the basic argument that Musk is laying out in his defense, and what civil offense is he accused of committing?
Well, this is a securities fraud action, and it actually follows on an SEC action where Musk agreed to a settlement. He agreed to pay $20 million to settle a dispute regarding these tweets. He agreed to step down as chairman of Tesla. And so what the shareholders are asking here is for billions of dollars in what they say are losses caused by the tweets. Now, you asked what his defense is. This is a really interesting case because the judge has already taken the first element of securities fraud off the table. Earlier in the case, before it got to the jury, the judge said these tweets were false and reckless. That's the first element. He told the jury when they walked in, assume that that is the case. And so what Musk is trying to do here is undermine the next elements. When you talked about the fact that he said, I had no ill motive, that's because the next element here is knowledge of wrongdoing, intent to do something wrong. So that's why he's saying, I had no ill motive. He's also saying, I did have the funding. I had the funding from SpaceX. I had the funding from the Saudi Public Trust Fund. And he's trying to say, you can't connect my motives and the losses that were incurred here.
So what would prosecutors have to prove in order for Musk to be found guilty?
What prosecutors have to prove is, or it's actually a plaintiff's attorney in this case would have to prove that he knew, that Musk knew that he was engaged in wrongdoing when he made those false and reckless statements, that investors sold or bought shares of Tesla in reliance on those statements, and that they lost money as a result of relying on those statements. So again, connecting the tweets to the economic loss that shareholders suffered, that's really what the plaintiff's attorneys have to show here.
So he's already paid a fine for this behavior, and now we've got this civil suit. I mean, what does the penalty look like? Would he have to, I don't know, pay shareholders what they think they lost?
So it's potentially billions of dollars. This is a really rare case, not just because, as we talked about, they already took the first element of securities fraud off the table by the judge saying, look, these statements were false and reckless, but also because it's a class action dealing with securities fraud. And when you have that situation, you have a case where Musk could be facing literally billions of dollars in damages if, again, the jury believes that he knew he was doing something wrong, that shareholders relied on that, and that they lost a lot of money as a result. In a lot of ways, this is a test case because typically these cases are settled. Musk is really no stranger to litigation, and he clearly did not want to settle this case despite having settled the SEC action.
All right, Jessica, always great to have you. Thank you.
Thank you.